Welcome everybody. Thank you for joining me on this Moorcrofts Employment Law update. I'll be talking for about an hour, including some questions at the end if we've got time. Okay, so the agenda for this morning. We are going to be talking about the reform of holiday rights, some new family leave and protections, new flexible working regulations, a new right to carers leave. There's a new duty to prevent sexual harassment coming into force, and the possible resurrection of employment tribunal fees. And then the second half of the webinar is going to be an update on some case law. So, holiday reform. This caused a headache for a lot of practitioners and employers in the past. And now the government has introduced the Employment Rights Amendment, Revocation and Transitional Provision Regulations 2023. Frankly, I could probably do a whole webinar on holiday, but this is just an overview of what these regulations have brought in this year. So these regulations make key changes to holiday rights for workers with irregular hours and part-year workers as well. Irregular hours worker is someone who works, someone whose hours in each paid period is wholly irregular and variable. And a part-year worker is somebody who's only required to work for part of the year under their contract, or who has periods of the year of at least a week where they don't work and they don't get paid. So what the regulations have introduced is a new method of holiday accrual for workers with irregular hours or part-year workers, and employers will be permitted to calculate holiday entitlement as 12.07% of the hours worked in any paid period. So why do we do it at 12.07%? Well, we do it like that because 5.6 weeks, which is statutory leave, is 12.7% of 46.4, which is the working weeks in the year. So that's my Rachel Riley bit for the session. I won't be doing any more maths after that. And the regulations also permit employers to pay rolled up holiday pay at 12.07% as well. Some of you may remember that you used to be able to do that many, many years ago, paid rolled up holiday pay. That was then illegal, and you couldn't do that because it was said to discourage workers from taking holiday. But employers are now allowed to pay a holiday pay enhancement on top of a worker's wages at 12.07%. Workers won't be able to dictate that to the employer. That decision will rest with the employer. So you will be able to pay the enhancement of 12.07%, or you can pay holiday pay as holiday pay when they take the holiday, or at the end, for example, of a period of work that they've done for you when they won't be doing any more work after that. And these have been introduced to temper the effect of the Harper, Trust and Brazel case decision, which was around a couple of years ago. And that created a rather strange situation where part-year workers could actually end up being paid more holiday than their part-time counterparts who may actually work more hours than they do, which was a slightly odd effect. So the government has tried to do something about that by introducing this. And that, of course, this is for holiday years on or after the 1st of April 2024. So if your holiday year that you're in now is from January to December, you won't be able to start doing this until after next January. Okay, so now we're looking at normal remuneration for holiday pay. Again, something that has caused a little bit of a headache for practitioners in the past as well. So the existing position in case law, as some of you may know, is that normal remuneration for holiday pay should include payments that are intrinsically linked to performance, like commission or bonuses that might be linked to performance and that are regularly paid as well. Payments for professional or personal status relating to length of service, seniority or qualifications, and overtime payments for that are regularly paid in 52-week period as well. So this enshrines existing case law, but employers should have been paying this properly. But we find that many employers don't. This is something that when you're looking at your pay reference period, you have to look at 52 weeks. So if you're looking back for somebody who's regularly been paid commission, for example, you look back 52 weeks. If there are weeks within that period where that person hasn't worked or been paid, then you have to go back a further few weeks to have 52 weeks to look at to find the average remuneration. So if your employee gets paid £50,000 basic, for example, basic pay a year, but they've earned £60,000 in salary, when you're calculating what they should be paid for their holiday, you need to calculate by reference to the 60,000. And that's with reference to the 4 weeks of EU leave under Regulation 13 of the Working Time Regulation. So there are two aspects to holiday entitlement in the UK: 4 weeks leave, which is based on the EU directive, and 1.6 weeks additional domestic leave. I always think of those as the 8 days bank holiday, because 1.6 weeks is 8 days. You can pay the 4 weeks EU leave at the normal remuneration rate, which includes all the payments set out here. And the 1.6 weeks domestic leave can be paid at basic salary. You don't have to differentiate between those. You can pay it all at normal remuneration, but just check now that you are paying it correctly if you haven't already done that so far. The regulations also deal with carryover of holiday, and again codify existing case law regarding carryover. So workers, employees are entitled to carry over 4 weeks of annual leave if they haven't been able to take it because they've been off sick. And those on family-related leave are allowed to carry over the entirety of their 5.6 weeks statutory leave. They should take their sick leave, their 4 weeks sick leave, if they've carried it over within 18 months of the end of the holiday year in which the entitlement was originally given. In addition, the regulations state that workers can carry forward untaken holiday if, for example, employers don't recognise their right to paid annual leave. So, for example, if they've been wrongly treated as self-employed, you may remember the famous case of Smith Pimlico Plumbers on that one, or if they haven't been given a reasonable opportunity to take the holiday or encouraged to take it, and they haven't been warned that they will lose it if they don't take it. In that case, the holiday can be carried over and over. So we would always recommend that you would put this in a policy or a contract. We would always draft it into a contract, the circumstances under which you can carry your annual leave over, and that you should take it, otherwise you would lose it, apart from these exceptions here, and that you must take within 18 months of the end of the following leave year in which you've accrued that entitlement. Okay, this cute little picture here is to demonstrate the paternity leave amendments that have come in. So the paternity leave amendment regulations 2024 have made some changes here. Fathers can now take 2 separate blocks of 1 week instead of 2 weeks altogether, and they can take that at any point during the first year after birth or adoption, rather than just during the first 8 weeks. The notice period has been shortened, which is about it's 28 days notice of the dates of their leave, with limited exceptions to that. And this is for those babies with an expected, or those mothers rather, with an expected week of confinement, 6th of April 2024, or those with the expected week of adoption on or after the 6th of April 2024. We've also seen the introduction of some additional redundancy protections. So you may already be aware that for a long time the law has protected those on maternity leave, adoption leave, or shared parental leave. They have priority. If you're going through a redundancy process and you have a suitable alternative role, they should take priority over someone else in a similar position who doesn't have that protection. So the maternity leave, adoption leave, and shared parental leave amendment regulations 2024 introduced that from the 6th of April, that period of protection is going to be extended for after people return to work. There's also protection for pregnant employees now as well. So they are protected from the date that they inform the employer of their pregnancy for the full period of their pregnancy, and that's where they inform the employer of the pregnancy on or after the 6th of April. For those on maternity leave and adoption leave, they are protected for 18 months from the first day of the estimated week of childbirth. That can be amended to the date, to be from the date that the child is actually born if the employee informs the employer of that, and that's for 18 months after that date. So if you think about it, if the woman has the baby and then she has 12 months maternity leave, it will be for 6 months after she gets back from maternity leave as well. Adoption leave, the individual is protected for the period of 18 months from the placement of adoption, and shared parental leave, you are protected for 18 months from the birth or placement for adoption, provided that the employee has taken 6 continuous weeks of shared parental leave. That protection won't apply if the employee is already protected by something else like adoption or maternity leave, and it has to be where the period of 6 continuous weeks of shared parental leave starts after the 6th of April. So in relation to that, what we would advise is that if you have a redundancy policy and it already covers this protection, just have a look at it and update it to reflect the current position. And also, if you are going to be going through any redundancy processes, make sure that you're aware, that managers are aware of the people who may have acquired this status, or who have just come back from leave, or who are on leave, or who are pregnant, etc. We also have some new flexible working changes here. Flexible working, a bit of a buzzword, even more so since COVID. We've got the flexible working amendment regulations here, and then Employment Relations Flexible Working Act as well. The current position, or the previous position, is that when employees make flexible working requests, they have to have 26 weeks continuous employment, and that's no longer the case. This is a day one right to request flexible working. Additionally, when employees set out their flexible working requests, it was quite prescriptive. They almost had to fill in a template letter where they explained the effect of their request for flexible working, the effect that that might have on their colleagues or the business. There's no need for them to explain this effect anymore, and they can make 2 requests in any 12-month period rather than just 1. And the employer is under an obligation to consult with them before they reject this request. And the time frame to deal with these requests is reduced from 3 months to 4 months. So you may find that you end up with more applications because of this. I think that's probably inevitable. And also, if you have a flexible working policy, you will need to update it as well to reflect the current position. We also have new carers leave rights under the Carers Leave Act 2023. This is from, again, the 6th of April. Things have been busy. Employees have a right to 1 week's unpaid carers leave if they have a dependent with a long-term care need. A dependent doesn't have to be someone who's a family member. It can be someone who relies on that employee for care. And a long-term care need is defined as a long-term illness or injury that can be physical or mental, that's likely to require care for more than 3 months. A disability is defined under the Equality Act 2010, or issues relating to old age. So this is 1 week's unpaid leave in each 12-month rolling period, and that can be taken as individual half days or blocks of a week. And the employee has to give twice as many days' notice or 3 days' notice, whichever is the greater. And employers are not allowed to refuse this request, but they can postpone it. Okay, moving on now to the duty to prevent sexual harassment. So this is a protection that's coming in later in this year in October via the Worker Protection Amendment of the Equality Act 2023. And this is going to put a new duty on employers to show that they have taken steps to prevent sexual harassment, or a new duty on them to take steps to prevent sexual harassment. Obviously, employers are liable for the discriminatory act of their employees, as well as being under a duty not to sexually harass their employees. So even if they don't know about the action of one employee to another, if that was sexual harassment, then they could still be liable. Sexual harassment is defined as unwanted conduct of a sexual nature which has the purpose or effect of violating someone's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for them. So currently, if you were taken to an employment tribunal by an employee with a sexual harassment complaint, you would have the statutory defence of showing that you had taken all reasonable steps to prevent that. For example, you'd fully briefed your staff before they went to a Christmas party. That's where it happened, that you had a policy on it, that you'd done training on it. You could show the employment tribunal that you'd taken all reasonable steps to prevent that. But this is going to be a new mandatory duty that will apply from October to show that you have taken reasonable steps. And these regulations, this Act also gives employment tribunals the right to award an uplift in any compensation awarded to an employee in employment tribunal for up to 25% if the employer is found to have failed in their duty to comply with this new duty. So the employment tribunal would take into account the extent to which the employer had failed. So, for example, if the employer has done very little to comply, like they don't even have a policy on harassment and bullying, then you would expect to see an uplift of probably 20% or 25% at the maximum. So the existing law on sexual harassment will remain, but this new duty will mean the likelihood that if you were taken to a tribunal for sexual harassment, that the employee will probably also plead that you haven't complied with this new duty, and the burden will then be on you as the employer to show that you have fulfilled that duty. So what can you start doing now to make sure that you're prepared for this that's coming in? Review your policies, your bullying and harassment policies, or you've got anything specific on sexual harassment in your equality and diversity policies. You may want to perform a risk assessment if you've got an area of your business where you think they might be particularly vulnerable to a claim, where there's employees, where there's lots of banter going on or something like that, where you could be vulnerable to a claim. You might want to provide training to your managers or other members of staff on sexual harassment, bullying, harassment in general. And you could also conduct some staff surveys to see whether or not people have been a victim of sexual harassment, or if they've observed anything that could give rise to a complaint, and make sure that you have a proper complaints process and grievance handling procedure as well. Okay, so we're also looking at the Ministry of Justice having a consultation on the possible reintroduction of employment tribunal fees. Some of you who've been doing this for as long as I have may remember that years and years ago, before the fees were introduced the first time around, when you used to call the tribunal, you'd ring and someone would answer the phone to you. Tribunals were fairly busy, they were fairly well run. Unfortunately, they are creaking under the weight of a lot of claims at the moment. This is partly because in 2013, when the fees were first introduced, the fees are quite high. They're around £160, £180 a claim. That area of work really just dropped off, and the employment tribunals were not very busy at all because costs were prohibitive and people weren't bringing claims. And because of that, the tribunals did get rid of a lot of their staff. And then once those fees were abolished for being unlawful, perhaps they didn't really restart to the extent that they had been before those fees. And then what with COVID and the backlog of claims, they're really creaking under the weight and they're under a lot of pressure. So it's been found that this is costing the taxpayer about £80 million. So they are looking at introducing fees in the tribunal and the appeal tribunal of around £55 per claim. And this is to try and relieve some of the costs to the taxpayer, and also to incentivise early conciliation and better engagement with ACAS, effectively to try and settle claims before they go all the way to a full merits hearing and alleviate the pressure on the tribunal service. Some claims will be exempt for because they're means tested and so on as before. Right, okay, so we're going to go on to a case law update now. We're looking at a case on belief discrimination, parental leave discrimination, and liability for discrimination under TUPE. I'm also going to be looking at some flexible working news and a pregnancy and maternity discrimination case and a whistleblowing claim as well. Okay, so this is an interesting case. You might have read about this in the press, called Anuba and Michael Garrett Associates. So this is a case about a Christian actress who got the lead role in The Colour Purple, stage production. You may remember this film from years ago. Whoopi Goldberg was in it. It's also a book. The actress didn't realise at the time that the play depicts a relationship between two women, so a lesbian relationship. Before rehearsal started, the claimant, some years ago, before this production, had put a Facebook post up about homosexuality being sinful and how Christians should stick to their belief on that point. This comment, this Facebook post, was retweeted before rehearsals, around the time rehearsals were to start, and the claimant was dismissed. She brought claims of religion, belief discrimination, harassment, and breach of contract. She also acknowledged, and this is quite important, that she wouldn't actually have gone on to play this role when she realised that there was a lesbian relationship after reading the script. So the tribunal concluded that although her beliefs did qualify for protection, she failed in her claim. The claimant appealed to the Employment Appeal Tribunal, and they rejected her appeal, and they agreed with the tribunal. In terms of direct discrimination, they said she wasn't dismissed because of her belief. She was dismissed because of the adverse publicity that this retweet had generated and the possible effect that would have on the cast, the crew, the audience, the producers, and the possible adverse impact that that could have on the on ticket sales and the commercial success of the play as well. And they also said, in terms of her harassment claim, that although she experienced the act of dismissal as being hostile, was it reasonable for it to have had that effect? They said, yes, it was a hostile act, but it wasn't reasonable for it to have had that effect on her because she was given the opportunity to change her position. Everything was explained to her, she understood, and she refused to change her position on that. So this is another case about religion and belief, which we have covered in previous webinars to some extent, to rather a large extent, in fact. And I think the importance in this case was the negative impact on the respondent in terms of her expression. It was doing damage to the business. So dismissing wasn't discriminatory. And the tribunal and appeal tribunal had particular regard to the commercial situation that had created for the respondent. So that's something worth remembering if you have employees that are expressing their beliefs in such a way that it could damage the business. Okay, so we're now moving on to the case of Hilton Food Solutions and Wright. So this is a case about a logistics supply chain manager who was dismissed by reason of redundancy. And this is essentially about the entitlement to take unpaid parental leave via the Maternity and Parental Leave Regulations 1999. Now, as an employer, you may have a policy on this already, and employers are at liberty to write their own policy on this. Obviously, it has to comply, it be legally compliant, but you can dictate a policy of how you want employers to apply for this kind of leave. But if you don't have a policy, then this will resort to the default position under the regulations. So, in terms of an employee applying for this kind of leave, what the regulations say is that an employee may not exercise any entitlement to parental leave unless they've given notice to their employer of the period of leave that they propose to take, and the employee's notice must specify the dates on which the period of leave is to begin and end, and must be given to the employer at least 21 days before the date on which that period is to begin. And an employee will be automatically and unfairly dismissed if the reason or principal reason is that they sought to take unpaid to take parental leave. Okay, so the facts in this case were that Mr. Wright was a logistics supply chain manager. He was dismissed by reason of redundancy. He had sought to take parental leave. Now, he hadn't made any formal application. He hadn't made a written application, but he had spoken about his intention to take that leave with various personnel at Hilton Foods, including HR and including his line manager. He also then approached the MD and he told him that he would be seeking parental leave. The MD told him, you are expected to be in work at the office Monday to Friday, 8 AM to 5 PM, no exceptions. So Mr. Wright then in return said, well, I'm going to take some unpaid parental leave because I have the right to do that. And the MD said, well, you can go effing legal there. Mr. Wright then complained to HR about this and brought it up with them, to which the response was, oh, well, that's just the MD, that's what he's like. So he was then dismissed and he brought claims. Hilton Foods applied to strike out his claim on the basis that it had no reasonable prospects of success. And they said that this was because he'd failed to comply with the provisions under the maternity and parental leave regulations. And he should have made this application properly in writing. And at the preliminary hearing, the employment tribunal did not allow this application for strikeout. Hilton Foods then appealed and they argued that the regulations are prescriptive and they require a formal written application. So the EAT said, on a straightforward reading of the regulations, there actually isn't an absolute requirement that an employee must have given a notice as set out in Schedule 2 to these regulations for that employee to have sought to take parental leave. And they interpreted the word sought here, and they applied a purposive approach to the regulations. So they try and interpret the regulations in a way to give rights to the employee. And they state to decide whether or not a stage had been reached where it can be said that the employee had sought to take parental leave. And they said that if Parliament had intended to limit the protection against dismissal to employees who'd given notice so that they were entitled to take parental leave, wording to that effect would have been used. Instead, what it created was two concepts: an employee who has sought to take parental leave and an employee who is able to exercise a right to parental leave because the relevant notice has been given. So this is a reminder to employees about the protection this is a reminder to employers about the protection given to employees who have sought to take parental leave from both detriment and from dismissal. So even if you don't get something in writing from your employee, they could still be protected if they've sought to take parental leave in this sort of way. Okay, so we now have the case of Sean Pong Tyres Limited and more. So this is the case about the transfer of undertakings protection of employment regulations 2006, or the TUPE regulations as we like to call them for short. I think many of you will be familiar with these already. So this involves transfer of rights, powers and liabilities from one employer to another, which can happen on the sale of a business or part of the business, and can also happen on a service provision chain. For example, if you've got an outgoing IT contractor and the incoming takes on the employees, and all those rights, powers, liabilities and duties transfer as well. So Mr. Moore, the claimant, was employed by Sean Pong Tyres until he resigned in April 2021. In June 2021, he brought a claim alleging that he'd been harassed and discriminated against by another employee who was called Mr. Owusu under the Equality Act 2010, and that he'd been constructively and unfairly dismissed. His claim was against Sean Pong Tyres, not against the individual Mr. Owusu. In July 2021, Mr. Owusu then transferred to another company, Credential, which the respondent later argued was a TUPE transfer. So it didn't make, the respondent, Sean Pong Tyres, made no mention of this TUPE transfer in their original ET3, their defence to the claim. And they didn't mention it at a preliminary hearing that took place in September 2021 either, when a list of issues was drawn up. So the first that they first time they brought this up was on the first day of a 3-day final hearing in January 2022, after the claimant had given evidence. So they made an application to amend their defence and argue that liability for the claims had transferred to Prudential. The tribunal refused to allow this application, and they said that the key consideration in this was the balance of prejudice to the parties. And what they said was refusing the application would mean that the respondent lost the opportunity to enter their defence and amend their defence, but this was a very late application and it actually involved quite a fundamental change, and it was going to have to also involve the production of evidence of the alleged TUPE transfer as well. And it was going to cause a big delay because they were going to have to join Prudential to the proceedings as well. And the respondent hadn't really offered any real explanation as to why they'd never brought this up before. So in the circumstances, the tribunal said the balance of prejudice was in favour of Mr. Moore's claimant, so it refused the application. The respondent then appealed to the EAT and argued that the liability of an employer to a claimant employee under the Equality Act was a transferor's liability under or in connection with the perpetrator's contract that would then transfer if the perpetrator transferred. The judge at the EAT dismissed the appeal and held that the liability under the Equality Act would not pass to a transferee under these circumstances. In these circumstances, the EAT noted that the claimant had resigned well before the alleged TUPE transfer and for reasons unconnected with it. So his employment at all times was with the respondent, and accordingly, the liability for the unfair dismissal lay with the respondent. So it's important to note in this case that actually there'd been no previous authority on this, and there hadn't been case law on this particular point before. I think the takeaway from this is that liability doesn't transfer unless the claimant does, but also remember that liability does transfer into the transferee for a lot of on a slightly different set of facts. So just be aware. In this case, it didn't, obviously, for the reasons that we've mentioned. Okay, this isn't a case in particular, but I wanted to bring up hybrid working because we get a lot of inquiries about it. And again, as I said before, it's a bit of a buzzword, even more so since we've all been coming back in since COVID. So it's been reported in the press that Boots has ended its hybrid working policy. They were doing 2 days a week at home and 3 days a week in the office, and they want to call people back now 5 days a week into the office. The independent consultancy firm Grant Thornton has produced a report to say that this raises equality issues, and they've reported that 50% of male CEO businesses are office-based compared to 40% headed by a female CEO, and that businesses in which workers are primarily office-based are the only ones in which the percentage of women in senior management roles drop below the global benchmark. So I think this is quite an interesting study, and it's just something that's worth remembering when flexible working requests do come into you, and obviously take advice as and when. Okay, so we now have the case of Ladd and Lilyhead Dental Practice Sales Limited. This is a case about WhatsApp groups. I'm sure you're all a member of a WhatsApp group. I am a member of 200 myself because I have children who are at school. This is a case about a lady who was on maternity leave, and she brought claims of pregnancy and maternity discrimination. The majority of her claims were not actually upheld by the tribunal. She was a sales negotiator for a dental practice. She went off on maternity leave and she lost her phone. She asked the employer for a replacement because she wanted to be allowed to continue to access a work WhatsApp group. This was refused and the employer would not replace her phone. The ET found that the question was that the decision not to provide her with a replacement and therefore exclude her from the WhatsApp chat was reasonably and objectively to be viewed as less favourable treatment for somebody on maternity leave, and that it was detrimental treatment. So this is an ET case only, so it's not binding on other courts. But I thought this was particularly interesting because we do get inquiries about contact and communications with women when they're on maternity leave and how much communication that you should have with them as an employer. Obviously, some women who go on maternity leave can feel quite isolated and taken out of day-to-day life and day-to-day activities with work, and they want to be a little bit connected with work during their mat leave. For others, no, they want to be completely immersed in the motherhood experience and forget about work. I think it's probably important before your employee goes off to establish with them the communication channels while they're on maternity leave and the sort of levels of communication that they are expecting, or that you can agree with them as well. Okay, so we're now going to move on to a whistleblowing case. This is the case of Nicol and World Travel and Tourism. So Mr. Nicol was the VP of Communications and PR at World Travel and Tourism, and he had raised concerns to HR about the president and CEO, Ms. Guevara. So the respondent, World Travel and Tourism, had 2 HR consultants working for them. And Mr. Nicol sent an email in August 2019 raising these concerns about Ms. Guevara. The HR consultants were then conducting some workshops with junior staff at which similar concerns and complaints had also been raised about Ms. Guevara. One of the HR consultants then told Ms. Guevara that complaints had been made about her management style. Shortly after this, in October 2019, Mr. Nicol was dismissed by reason of redundancy. So he brought claims of automatic unfair dismissal and a detriment as a result of making protected disclosures. His claims were actually dismissed by the Employment Tribunal. The tribunal found that Mr. Nicol, when he was dismissed by reason of redundancy, that there wasn't actually a genuine redundancy situation. When looking at automatic unfair dismissal and detriment as a result of making protected disclosures, we look at 43A and B of the Employment Rights Act. So protected disclosure means a qualifying disclosure, and section 43B provides that that means any disclosure of information which in the reasonable belief of the worker making the disclosure is made in the public interest and tends to show one or more of the matters listed here. So that a criminal offence has been committed, is committed or is likely to be committed. That person has failed, is failing or likely to fail to comply with legal obligations. Miscarriage of justice has occurred, is occurring or likely to occur. That the health and safety of any individual is being or is likely to be endangered, and the environment has been, is being or is likely to be damaged, or that the information tending to show any matter above is being or likely to be concealed. So the tribunal also found that Mr. Nicol had made a qualifying disclosure to the HR consultants on that occasion. But the tribunal found that the email did not come to Ms. Guevara's attention until the legal proceedings. They dismissed his claims and he appealed to the EAT. He took issue with a large number of the tribunal's findings. He complained that the tribunal had applied an inappropriate approach to the legislation as regards the protected disclosure. He made the protected disclosure to one of the HR consultants, which was then transmitted to Ms. Guevara. And he said that the tribunal had put almost a new obstacle in place for him to get over in terms of conveying the detail of the disclosure to person B. So person A being the HR consultant, person B must have been told some detail of the disclosure by person A, which is what the tribunal said. So on appeal, the EAT also dismissed the appeal and agreed with the Employment Tribunal. They said they were correct. Now, the EAT did note that there was no case law on this point. They said that the question was whether it is sufficient for person B, in this case Ms. Guevara, merely knows that a disclosure has been made to person A, or whether person B needs to know at least some of the content of that disclosure. And the EAT said that the latter was required for whistleblowing liability in respect of automatic unfair dismissal. So in this case, I think we're looking at a decision that could really be appealed now, because I think this decision seems a little bit unfair. There seems to be a bit of a void in the protection offered to whistleblowers here, because it is like an an additional hurdle to get over, if you like. And I do think that in this case, for example, Miss Guevara could have known very well her own wrongdoing, and she could have known very well when the HR consultants told her about the complaints that the detail of what Mr. Nicol may have said. So I think the takeaway from this is that next time a similar case comes up, that this could potentially go the other way on a similar set of facts. But so I wouldn't take it for granted if you received a similar complaint that it would be okay to dismiss and that that person wouldn't be protected. I think approach with caution. Okay, so I think we have some questions now. I think if Marie is online, some questions may have come in.
Yeah, so Lindsay, we have received quite a few questions. So if I just read the first one out for you.
Okay.
What if you have two people coming back off family leave around the same time and you're going through a redundancy process and only one suitable alternative role? Who do you give priority to?
Yeah, okay, yeah, that's an interesting question. Yes, so in that case, you can't give priority to one over the other. So you'd only be giving priority the person coming back off mat leave, for example, if the person that they were standing next to, if you like, in the redundancy process wasn't. So if you've got two the same, then you would have to deal with them equally as you would using your selection criteria and your scoring.
Okay, next question. So we have a policy on taking unpaid leave and the employee has to put the application in writing. If they don't put it in writing and just say they want unpaid parental leave because of the Hilton Foods case, does that mean they won't have to put it in writing?
No, they'd still have to put it in writing because that's your policy. What the Hilton Foods case does is that it protects an employee from dismissal, for example, if they haven't put it in writing and they've just mentioned it to somebody and then you dismiss them because they'd asked for the parental leave. So it doesn't mean that that the employee shouldn't comply with your own policy. Yes, they would still have to do that.
Okay, and the next question. So if my employee is on maternity leave and tells me that she doesn't want any communication from work while she is off, should I still invite her to the Christmas party?
Yes, okay. So I think it's important before employees go off on mat leave or other forms of parental leave that are longer than 2 weeks, for example, to establish what kind of communication or how much communication they want before they go. So if they categorically say they don't want that level of communication, then you may have to ask, does that include not inviting you to the Christmas party? And just establish some ground rules for that, I think. Obviously, you're under an obligation as an employer to communicate with your employee when they're off, but obviously there are certain things that would take precedence. So for example, if you were going through a redundancy process or if the business was being sold, you'd have to communicate with the employee about that, but obviously not perhaps for things like we're having a new carpet fitted in reception or whatever. I hope you found that interesting, and it was good to see so many participants. If you've got any other questions, as I say, please do get in touch and I'll try my best to get back to you. And hopefully you'll join us on the next one. Thank you very much.